Taxplaining, Episode 1, The Night of the Moratorium Roundtable. Welcome to Taxplaining, your go-to podcast for lively tax and legal talk. I'm Mary, and joining me is my co-host Ashley. Together, we're the tax attorneys ready to taxplain. In today's Express episode, we're recapping the riveting meeting we just attended with IRS officials and a very select group of tax professionals discussing everything ERC moratorium and its ripple effects on our clients. So sit back, grab your coffee, and let us taxplain.
All right. Here we are for the first episode of Taxplaining. Thank you so much to our taxplainees that have decided to tune in for our first exciting podcast. The employer retention credit is something that's been top of mind and has caused a lot of heartburn for tax practitioners and small business owners. For those of you newer to the space, just high level, the ERC was created by Congress in an effort to reward businesses for keeping employees on the payroll despite the hardships of the pandemic. I won't go into the nuances of eligibility or any of that. We can cover some of those topics in a deep dive later on. But for today's call, Mary, why don't you explain how this call with IRS officials came together?
Sure. You just described the very basics of the credit itself. What we know has happened in the interim is this moratorium. And for the novice individual out there, it just means that the IRS froze everything. They hit the pause button, and none of the eligible businesses right now are getting the relief that they expected to receive for doing what Congress wanted them to do, keeping employees on payroll during the pandemic. And the reasons for the moratorium are sus. The IRS just hasn't volunteered any actual evidence or logic for it that's persuasive. It's really anecdotal. And so an IRS official connected with me and wanted a fresh perspective, one that was centered on hardships, real life hardships that eligible clients are facing due to the moratorium. And I was excited to hear this. It's not something that you hear every day. They said pick a team of a diverse group of experienced practitioners, not necessarily just tax attorneys. It can be CPAs, it can be EAs, whatever. They didn't give me a number, a maximum limit at first, but then they whittled it down after I'd already started the process and after some of the others I'd already invited had started collaborating with me to get that list defined. So it ended up being a total of 9 practitioners allowed on the call. We got to make suggestions for improvements with the process. We got to share anonymously, but share the real life examples and just had a really great discussion. And everybody came together in a way that I think we are all missing. There's a lot of division in the arena right now, the ERC context. And I think I'll wrap on that later at the end of this. But this call in particular brought all of us together in a way that was needed.
Mary, I did want to point out how diverse the group of practitioners was. I think you did such a great job pulling it together for that reason, because there was just a wide variety of perspectives. And one important thing to point out too is, in a cruel twist of irony, the delays that people are experiencing are causing businesses to shut down, which is literally the exact opposite of what the law was enacted for. Anyway, I just wanted to mention, kudos pulling the practitioners together. I think everyone has such a great, interesting perspective, and hopefully it's beneficial to everyone listening, but I know it was personally beneficial to me. And I think I was really pleasantly surprised with the IRS response and their willingness to let us vent our frustrations and concerns. It really seemed like a true intention of trying to solve some of these problems. One other thing that I wanted to mention, I think it speaks to how profound this call really was and really a little bit groundbreaking, is that when you look at how the IRS has processed ERC from the beginning, there has been a real lack of transparency for practitioners to be able to predict for clients when they might get their credit, to be able to predict how the IRS, despite all the guidance that has come out, how the IRS will treat certain positions. And so to get this really unfiltered access and an audience with the IRS where they were legitimately listening and problem solving and triaging and hearing what we had to say, I think that really speaks to your context at the IRS and the group that you put together.
And you really hit the nail on the head there with uh, transparency. That was one of the buckets, if we want to call it. I think we all walked away from the call with two buckets in mind of critical issues: a bucket of transparency issues and a bucket that featured IRS inconsistencies in play.
Absolutely. And I think it's interesting to point out too that those categories sort of came about in hindsight. Each of us brought a very different perspective to the table. We all brought up various issues, but they all, in hindsight, really fit into one of those two buckets very
Absolutely.
neatly.
So, with that, I think the number one, or the one we're going to bump to number one here, has to do with TAS involvement. It has to do with when your effort to help your client via the TAS route, specifically a Form 911, when that's really right. Ashley, do you want to discuss what was said about that?
Yeah, definitely. And of course, when we say TAS, we're referring to Taxpayer Advocate Service. And there is a TAS office, I think, in every state, at least one. Some states have more than one. And those issues that are ripe for TAS involvement are brought to the taxpayer's local office. And that can be found on the Taxpayer Advocate website. But essentially, what makes a claim ripe for TAS involvement, and this was clarified specifically on the call after somebody posed the question, when should Taxpayer Advocate get involved? And part of the reason for the question is that practitioners are experiencing so many inconsistencies depending on which TAS office you're talking to. So you may be talking to Austin, you may be talking to one in Utah or Oklahoma or Maryland, and you may get a different response. Some seem to have very robust procedures for the intaking and processing ERC claims specifically. Others, we have been told they're not going to get involved in any ERC claims, which we're told by those IRS officials on the roundtable the other day that that is not a correct response, that TAS should absolutely be getting involved in ERC claims when they're ripe for TAS involvement. So the criteria that we were given on that call are: if the ERC claim was filed pre-moratorium, which would be pre-September 14th of 2023, that makes the claim ripe for TAS involvement on its face. The practitioner or the taxpayer does not have to demonstrate that there is a financial hardship, as with most cases where TAS gets involved. Now, if the ERC claim was filed post-moratorium, the taxpayer or the representative must show that the taxpayer is experiencing financial hardship due to the delay in processing the ERC claim and issuing the refund check. Now, I will say there have been, because my firm has been monitoring transcripts for our clients, as many other practitioners and you have done, Mary, we do see sometimes that the claim has been processed by the IRS, but the check has not been issued for whatever reason. And we can get into some of those nuances probably in another episode if there's interest, but there are kind of two parts to this: the IRS processing the claim, but then also the other issue we're seeing delays with is actually clients getting those checks And so those are the two ways really that TAS should get involved in the ERC claim, either with filed pre-moratorium or with filed post-moratorium, post September 2023, and the taxpayers experiencing financial hardship, such as bankruptcy or potentially going out of business, whatever that may be.
Yeah. And then sort of the follow-up to that question or part of the discussion was, what's the reasonable amount of time that people should be expecting a response back from TAS, even just as to whether they're going to accept the 911 or not. And it was interesting because at least one practitioner on the call shared that there was a case for her that it'd been at least 5 months, maybe more than 5 months, since they'd heard anything back from filing the 911. And so, giving up, they started a congressional action instead. And then, of course, TAS decided to get involved. And now the practitioner has sort of this dueling TAS v. congressional action going on. And, the practitioner's question was poignant. I mean, how long is reasonable? And the IRS officials on the call were unanimous in a robust 5 months is unreasonable, and it should be 4 weeks. Taz is really busy, but 5 months is just too long. So I do feel like the IRS on the call took that to heart, and I believe that they're going to keep that in mind and address it as best as they're able to. But the reasonable amount of time is really 4 weeks.
Yeah, that's an excellent point. I think a lot of practitioners have been wondering that very same thing. And so I'm glad that that question was asked. Some of the issues that were brought up, the official pointed out were systemic. And so TAS looks at things a couple of different ways, from my understanding. And part of their role is to hold the IRS accountable. And they report to Congress every year, as many of you know, and in a big report, which I think we're due for one. Is it this month?
Months, June.
So we all should look for that. And I'm curious to see if any of the issues that we brought up on the call will make it, or if they were past the deadline. But
I think they're going to make it.
I'm sure ERC will be addressed either way.
That's a
So as far as systemic versus what I refer to it as more of a direct issue involving a specific taxpayer, there are systemic issues that many taxpayers are experiencing as a result of processing errors or lack of process. A lot of ERC, the way it's processed with the IRS, I've noticed, isn't even covered in the IRM. Certain things, certain aspects of ERC claims are covered in the Internal Revenue Manual, which tells the IRS how they are to process certain things. But some of it, I feel like, is probably the policy or the procedures are set forth by more of an informal internal memorandum or something like that. And so those were told anything that's a systemic issue, and we can talk about some examples, should be reported to TAS via its systemic advocacy management system. But issues such as many taxpayers who filed their original 941, then subsequently filed the 941X to claim the ERC refunds, are seeing now suddenly their original 941 is missing for some reason. And it's not just a handful of taxpayers, it's quite a few. And so that's something we would call systemic issue. On those systemic issues, in addition to reporting them through the systemic advocacy management system, or SAMS, is it? The practitioner should also involve the taxpayer advocate in the client's jurisdiction directly in order to address that issue directly for that taxpayer. And so that's kind of the two different ways these issues need to be addressed, both systemically and directly with the appropriate taxpayer advocate office. Other systemic issues, a big one mentioned on the call, was practitioners are now seeing that IRS refuse to apply ERC refunds to past due payroll tax balances. Something that we together came up with on the call was Well, the relevant code section actually does not mandate that the IRS apply overpayments to past due balances. It's more permissive in the way that it's written. There's probably some case law or guidance on the issue. I confess I've not had time to dig into it, but the taxpayer or the IRS representatives all seem to agree that that statute is really more permissive. But kind of across the board, practitioners on the call were noting that they were experiencing now suddenly a change, a deviation from prior procedure, where we used to see those overpayments that were resulting from an ERC refund. We used to see those in pretty much every situation be applied to a past due payroll tax balance, which why wouldn't the IRS want that money? I have some opinions on that too. We'll get into another time. But now we're seeing a change from that procedure. And so what's happening on the transcript, you're seeing that ERC refund sitting there with no movement. And you know the taxpayer has a past due payroll tax balance. That ERC refund a lot of times will wipe out that balance. And that taxpayer may still get some money refunded to them, but the IRS is refusing to do that. What they're requiring instead is that the taxpayer resolve that past due balance separate and apart from the ERC refund, and then they'll release the funds. And so whether that's right or wrong, I, again, haven't had time to dig into it. I don't know if you have, Mary, but
I haven't, but I think it's really important that we brought that up, and the 941, the systemic 941 issue that you mentioned just before that. I think it's important we brought it up because of all of the systemic or potentially systemic issues, I think those two hit the IRS the hardest, the ones on the call the hardest. They were really surprised to hear that offsets weren't happening, that those funds were not going back to previous balances.
potentially another systemic issue is the issue of stolen checks. There are taxpayers reporting that they've never received their check, and it evidently was stolen because the IRS transcripts show that the check was sent. But there is a form that you can file for your clients if the check has been stolen. However, the IRS is refusing to do anything about those stolen checks, despite the taxpayer having gotten proof from the bank to show the taxpayer did not deposit the check into their business account and other proof.
Yeah, they're refusing help. The IRS is not reissuing the checks. And this, by the way, it's not happening in one of these ghost preparer settings. It's just theft, but it sounds like a systemic issue.
Another one mentioned that I think is important is that taxpayers are receiving letters from the IRS indicating that there's an issue with their ERC claim, and a knowledgeable practitioner that knows all the ins and outs of ERC looks at it and says there is no issue. And so my advice there to practitioners, especially CPAs that are helping clients sort these issues out, and the CPA maybe did not handle the ERC claim. As with anything IRS related, don't take what the letter says on its face. Really dig in and fight back and advocate for your client if those letters are inaccurate. Some other issues that were brought up, but a solution was not necessarily posed during the call by IRS officials, but we got their attention, they acknowledged it, and I expect a solution at some point. One of them is that the IRS is broadly taking the position that CMS or Centers for Medicare Services guidance was optional, that compliance with that guidance was optional. Now, there's a major problem with that position. That would be hospitals, senior living facilities, really important entities, especially in a pandemic. They have to keep people safe. They're legally bound to follow the CMS guidance. We all know that from a logic and reason standpoint. Where we go wrong sometimes is assuming that the IRS operates based on logic and reason, apparently. But I can say there is differing opinion among ERC practitioners as to whether CMS guidance fits the definition of governmental order for ERC purposes. In some states, there were corresponding orders from the governor, mayor, public health official that did rise to the level of a governmental order that had either adopted what was contained in the CMS guidance or simply said these businesses are ordered to follow CMS guidance, which kind of should probably go without saying. But that is something that was brought up and brought to the attention that the IRS is really taking this broad position on CMS guidance.
So, unfortunately, while that topic doesn't have a solution at the ready from the IRS officials that we spoke with on the call, it has been brought to our attention that, at least in one instance, an IRS examiner did appear to find a CMS order or orders sufficient, and it was a success. So we are hopeful that maybe Taxplaining will get to interview the practitioner involved with that and get the full story. I can't give more than that, but that's at least a hopeful sign in my mind.
Yeah, definitely. I know it's a hot topic. I will say, I know there are some of us who have reached out to attorneys for Health and Human Services and CMS specifically to get something in writing saying that CMS guidance was absolutely mandatory for those businesses that come under the purview of CMS. And I can say here that I did receive something back saying absolutely these businesses would be shut down or would have been shut down if they did not follow CMS guidance. Now, I will also caveat that with we know that enforcement or enforceability doesn't necessarily matter when we're talking about the definition of order. And so we'll just have to wait and see how that plays out. And I'm definitely curious to hear from practitioner that you mentioned, Mary, on the specifics of that audit and how they were able to make that argument and what the examiner required essentially in order for that to pass muster.
And I'm also really excited to follow the case law in this area because, in my mind, you get the sympathetic client, the long term care facility subject to these, at least de facto orders, and you get a sympathetic judge. And I think the IRS is going to take a hit with the right attorney arguing that case. It's just my opinion. But following the case law in that area is particularly exciting for me.
I agree. We will all rely on you to stay with those updates. Another issue that was mentioned was that there are IRS examiners apparently claiming that taxpayers cannot rely on Notice 2021-20 because it is the subject of litigation, which is kind of funny because that would mean that reliance on that only goes one way, and that's IRS can rely on it, but taxpayers can't. What do you think about that?
I think it's preposterous. And to their credit, the officials on our call, I think, felt the same way. It doesn't make sense. I I think it's silly.
I agree. Finally, kind of I don't want to say funny because none of this is funny, but curious issue that was brought up, sort of a one-off issue, was that there's at least one IRS examiner that does not believe a famous fast food chain is a restaurant and therefore was not subject to the governmental orders that shut down in-person dining. Although this fast food chain, I can assure you, does have table. They have a good number, we'll say more than percent, that dine at the restaurant. I don't even need to see the data on that one. I thought that was interesting.
It was amusing. So there is one examiner that does not believe that's the case.
Very interesting. To recap the overpayment interest issue, there are a good bit of claims sitting there accruing overpayment interest at a decently high rate. And taking a step back and assuming that a lot of it is, consists of valid claims, despite what the IRS has said, yes, there were bad actors, and yes, there is fraud in this space, and criminal investigations sorting that out right now in the Department of Justice. But given the fact that the moratorium was put in place last September, and there continued to be, despite some of those bad actors shutting down and getting out of the space, there continued to be such a high volume of claims, not to mention the claims that were filed in the 2 weeks between the HR, what was it, 7024, the tax bill, the 2024 tax bill, or so-called ERC killer bill, which you coined, between when that was announced mid-January and the proposed end date of ERC. It did not come to pass January 31st of 2024. Again, logic and reason assumes that those claims, most of them were valid because we had cautious taxpayers and cautious practitioners that had been waiting on additional guidance and clarity from the IRS in light of the moratorium and in light of all the fraud. They had been waiting to file, and then they find out, oh, ERC, it might end in 2 weeks. We better go ahead and get that valid claim in. So my point is, out of the 1 to 1.5 million sitting there, a lot of those are valid claims. That is generating that overpayment interest just continues to accrue at the overpayment rate. And that is going to cause even bigger financial burden for the government and for taxpayers in general. And this is a very big issue. So that is like a key takeaway.
I think also a final takeaway from my point of view, when you've been in the arena, the ERC arena that we've all been in these years, you pick up on, unfortunately, what's become a divide, at least from my perspective. I think there are these camps, and a lot of it is kind of a tax attorney v. CPA, unfortunately. And I'm not saying that's a rule and everybody, but I do think there's an alignment more so with CPAs on the IRS side of things, and then tax attorneys, doing what we should be doing. Gray areas are just part of it. But we're kind of against each other. And leaving the call with such a diverse group of practitioners on the call and the IRS officials that were there, it left me reassured and hopeful that that chasm that exists right now is going to close, at least somewhat, or that there really are some meeting grounds in the middle for all of us. So it was just a great call and a good feeling at the end.
I agree. And I would just add quickly that I think that realization was arrived at from both sides. So the practitioner side, I think a lot of us realized, hey, we may be seeing different issues or approaching things a little bit differently. And maybe we approach some things differently and when we were filing these claims, but we all cohesively can come together and present these issues in a unified front to the IRS, and also allowing the IRS to see it's sort of the bad actors and then all the rest of us.
That's a wrap for Taxplaining's first podcast. But don't worry, we have more to share. So be sure to tune in to the next episode. Thanks for joining us. And remember, when it comes to tax law, it's not just about the numbers. It's about the narrative and making it count.